This video will discuss how you might be able to start the process of reconnecting with your child or grandchild. Before we get started, I'd like to say that this video is not legal advice, and it's not meant to be a substitute for legal advice. It's meant to provide general information and is primarily geared toward those navigating these issues in California. If you find yourself facing issues reconnecting with your children or grandchildren, the first thing you should do, if you can't resolve those issues informally by speaking to the other parties involved, is to speak to an attorney who specializes in family law. First, let's talk about your rights and responsibilities in reconnection. Many people assume that parents and grandparents are granted automatic rights to things like living with, visiting, or making decisions about their children and grandchildren. Despite this, it's simply not true. In California, the law surrounding parentage is complex, and the rights and responsibilities of parents and grandparents are as well. The primary thing to remember regarding reconnecting with your children or grandchildren is that the law, and therefore the courts, look primarily toward the best interests of the child. This standard of best interests will guide every decision a court makes regarding visitation, custody, adoption, or any other situation involving minor children in California. For parents, California law assumes that a child's parents, whether they're biological or adopted parents, are going to make decisions that are in the best interests of their own children. As a result, parents are generally left to make whatever decisions they want or see fit when it comes to their children. If a court gets involved, either during a custody dispute or after an investigation by the Department of Children and Family Services, its decisions will be guided by the children's best interests as well. While parentage and parental rights are complicated, here are a few general points. For women, if you've given birth to a child, you are that child's presumed parent under the law and will have the right to care for the child unless you've chosen to give up your parental rights through adoption, you've lost custody or visitation rights in family court, you've had your child removed from you by the dependency court, or you've had your parental rights terminated or otherwise limited in a court of law. For men, it takes more than mere biology to establish the same level of parental rights and responsibilities in California. Generally speaking, unless one of the prior situations which would affect your rights applies, you'll be a presumed parent in California if you were married to the child's mother at the time of conception and birth, or you married the child's mother after birth and either agreed to have your name placed on the child's birth certificate or agreed to support the child, you signed a declaration of parentage, or you cared for that child for a relatively extended period of time and you provided financial and physical support while holding yourself out openly to be the father of that child, and you established a bond over that period of time. For that one, it mostly means, did you act as if you were the father of that child? You'll be considered the presumed parent also if you've been declared such by a court of law, such as family law court, dependency law court, or even if you and the mother have agreed that you were the child in a domestic violence case. It's important to note that biological fathers who are otherwise not involved in the lives of their children are not automatically granted rights in California. Like most states, California does not extend automatic visitation or custody rights to grandparents. Generally speaking, in California, parents get to decide whether their children will be permitted to visit grandparents. If a child's parents are married, the court will generally not even entertain a request for visitation from a grandparent unless it's supported by one of those parents. Because of this, if you're seeking to establish or reestablish a relationship with your grandchildren, it's best that you seek to make arrangements with their parents. An exception to the general rule of no rights for grandparents in California is that grandparents, like other relatives, do have preference of placement if parents are unable to care for their children. Now that we've talked a little bit about parental rights and parentage, here are some things that you might need to find out in order to get the process started to see your child again. First, you should find out if there are any court orders that could limit or stop you from contacting your child or your child's caregiver. It could affect your ability to reconnect with your child, so it's very important to know about them. You can find out if there are court orders by contacting the clerk in the local county court where your child's case is going on. You can usually call the clerk's office by phone or go in person when the clerk's office is open. Ask for copies of all the court orders in the case. Second, you need to find out if there are any conditions of parole, probation, or other types of community supervision that could limit or stop you from contacting your child or their caregiver. If you're on parole, probation, or other types of community supervision, you need to get to know and follow all the terms of your conditions of supervision. This includes any rules about who you can and can't contact, places where you can and can't travel, move, live, or visit. These conditions can impact your ability to see or visit your children, so be aware of them before you start contacting or visiting them. If there are conditions of your parole or probation that prevent you from seeing your children, you may be able to petition the court to modify these orders to allow you to see your children. If this situation applies to you, you should speak to an attorney about your situation as soon as possible. Third, you need to locate your child. If you don't already know where your child is, you'll need to know the location of your child and your child's caregiver if you want to contact that child and serve the caregiver with any court papers if you open a case. You also need to find out if there's a court case, an open case, or a past one involving your child or children. For parents, by law, when a court case is filed about a child, both parents have the right to be notified of the case, to be sent copies of the court documents, and have the chance to respond and participate in that proceeding. If there's a court case involving your child, it's best to contact the court clerk to request a copy of the court orders and any other documents about the court case, and ask to join the case if necessary. If there's a court case involving your child, you will most likely have to join that case as opposed to starting a new one to increase your custody or visitation rights. For example, if there's a dependency case, that puts on pause any family law case that's already going. Getting copies of all court papers, including court orders, is an important part of the process of learning about or joining a case. Court orders can explain your current rights and responsibilities with your child, including when and how you're allowed to visit and contact the child, or limiting or preventing you from contacting the child. If you want more custody or visitation, you may need to ask the judge to change this court order. If CPS or DCFS is involved in your child's case, ask the clerk at the dependency court in the county where your child lives for any court orders. You can also ask your county social worker or the dependency court judge for a copy of your case plan, which tells you everything you need to do to get your child back, if that's still an option at this point, and family reunification services, which are classes and programs to help you get your child back. If you're given a case plan by the court, it's extremely important that you finish the case plan and maintain contact and a friendly relationship with the social worker. You don't have to like them, you don't have to be their friend, but it's very important that you get along with them because they're the eyes and ears of the court, and generally speaking, the judge will believe whatever the social worker says. If there isn't a court case involving your child and there are no court orders, you may need to open a new case and ask a judge for more rights and responsibility as a parent if the other parent isn't willing to allow this without that court intervention. Here, it's important to note that if there's been a dependency case for your child while you were incarcerated, it's possible that your parental rights were terminated during your incarceration. If that's the case, you would have received a notice and an opportunity to participate in the court proceeding. If this is the situation you find yourself in, there's very little you can do as the law no longer sees you as a parent. If you know the caregiver of your child, you may be able to arrange to see your child if you're on good terms. But keep in mind that you'll have no legal rights in this case, and your ability to see your child will be entirely dependent on your relationship with the caregiver. If they're willing to let you see your child, don't burn that bridge, and abide by any conditions they give you. Whether it's in family court or dependency court, your criminal record can impact your ability to reconnect with your child. In each case, the judge will have to make their determination based on the child's best interests, and to do so, they'll look at anything and everything about a child and the child's parents that relates to the well-being of the child, and who's best suited to care for and have a relationship with that child. There are certain crimes like sex crimes and crimes that are considered violent felonies that create what's called a rebuttable presumption that a parent is not fit to have a child placed with them. This does not automatically ban you from reconnecting with your child, but it does mean that you'll have a much harder time convincing the judge that it's in your child's best interests to reconnect. Family law is a complicated and personal subject. It touches on the most human parts of us and the most important connections in our lives. The courts that deal with these issues are flawed, and they often make mistakes or are forced to make difficult decisions that all too often leave parents, particularly parents who've been incarcerated, estranged from their children. This video can't solve those problems, and it's far too short to give all the answers for every situation. Hopefully it has provided you some answers though, and pointed you toward the questions you need to ask as you seek to reconnect with your child or grandchild. Thanks so much for watching.